Well, ladies and gentlemen, now I'm just coming from Arizona, where, as some of you may know, the state has adopted a new law that criminalizes the failure to carry your immigration papers. And while in the cab driving to the airport, I asked the driver what he thought of the law, and he said, well, the governor's popularity has gone up from 20% to 65% as a result of the law. And I want to start with that because it shows the political context within which many of these laws that affect human rights operate. And I'm going to talk about the political context rather than the legal context, because although I have a law degree, it's been a long time since I've practiced law, and I'm what you might call a lapsed lawyer. And I wouldn't dare expose my lack of legal knowledge in front of such a distinguished panel. Now, so my purpose will actually be to talk about the global context within which the Human Rights Act in the UK has developed over the last decade. It is a domestic piece of legislation, but by its very nature, it is international. And it's the world that sets the agenda for human rights, as much for the UK as for elsewhere. And so we can't assess the future of Human Rights Act without understanding what's happening in that external world. Now, I'm going to look at 4 key trends, 2 that I regard as negative and 2 that I think are positive. On the negative side, the erosion of rights by the state in the name of security, and the erosion of rights by the market in the name of economic progress. And on the positive side, the extension of accountability for human rights across borders and the expansion of global civil society. I see these 4 trends as key trends that will determine the shape of the human rights landscape in coming years. Now, taking first the issue of erosion of rights in the name of security, well, the tension between liberty and security has haunted the human rights movement since its inception. We saw it in Eastern Europe with communist regimes during the Cold War. We saw it in Latin America with military dictatorships. We've seen it in many contexts with autocratic regimes. But in the aftermath of 9/11, of course, security gained certain legitimacy over human rights in a way in which it had never done before. And that was primarily because those very governments who championed human rights for all these decades were the ones who suddenly put security on the agenda, namely the Western democracies. So we actually saw bedrock principles such as the ban on torture, the prohibition of arbitrary indefinite detention, fair trial guarantees, protection against discrimination, all being challenged. Now, of course, the Bush administration is gone. President Obama has made promises, but those promises yet have to be substantiated. Guantanamo is still there. Bagram is still there. The whole issue of trial before military commissions remains rather unclear. So I think we need to be careful here. Just because an administration changes doesn't mean that necessarily laws or practices or even the application of those laws disappear. They remain on the book. And that's where one needs to look very carefully at what has happened in the UK and how that securitization of the approach to law and order, to the rule of law, is going to affect the Human Rights Act in the years to come. Now, the interesting thing, of course, about the UK is that even before 9/11, it had one of the most draconian anti-terrorism laws on its books. Al-Qaeda was already a banned organization. Yet, within days, as you know, the government rushed through the 2001 Act, which brought in basically what one would call internment. That was, of course, then thrown out by the House of Lords in December 2004. Immediately, the government followed with another piece of legislation about control orders. So you can see how the tightening continued in that way. Now, the big debate domestically has been about detention pre-charge. For how long can people be detained before being charged? And there's a whole debate about how many days, 28 days, 40 days, and so on and so forth. But in my view, the most damaging action actually has been in the area of the attempts to water down the prohibition on torture. Now, the UK has used multiple means to address this issue. Well, some of you will remember the case of A and others, where the government claimed that it could use evidence that had been obtained as a result of torture, providing that torture had not been carried out or condoned by British officials, providing it had been done overseas, in other words. Now, the House of Lords, of course, threw that argument out and said tainted evidence is tainted evidence. And in fact, Lord Hoffman used the words, "The use of torture corrupts and degrades the state which uses and the legal system which affects it." The legal system which affects it. And so that, you see the courts coming back on it. But that didn't deter the UK. It continued to seek other means, for instance, with diplomatic assurances. And diplomatic assurances are still there. That is still part of the policy by which the UK does deals with governments returning their nationals with assurances that they won't be tortured. Now, the interesting thing, of course, is that if you have to go and ask for an assurance, that means you know that that government practices torture. So, in a way, you're saying, yeah, it's okay to torture the others, just don't touch these guys because we are returning them. Now, then again, the other interesting aspect has been the way in which the UK has been looking at European jurisprudence. And remember, the Human Rights Act, of course, the courts have used European jurisprudence to interpret it. And there was a case, some of you may know, Ramsey against the Netherlands. This had nothing to do with the UK. It was actually a Dutch case of an Algerian man whom the Dutch wanted to return to Algeria. And the UK government, together with several other European governments, I think it was Portugal, Lithuania, and Slovakia, put in a third-party submission arguing that the court should set aside Chahal. You may remember the Chahal case, which goes back a couple of decades, and this was a case against the UK. I think it was a Sikh asylum seeker, an Indian Sikh asylum seeker, and the court had held in that case, the European court had held, that you could not return him to India because he faced the likelihood of being tortured. So the UK government tried to say, well, Chahal should be set aside because there should be a balance between national security and the prohibition against torture. Thank God, the European court did not succumb to that argument. There are, of course, other issues about the extent to which UK intelligence officers participated in interrogation of detainees in Bagram and Guantanamo. There's the whole issue of renditions, to what extent were UK airports used for renditions, UK territory used for renditions, and all that whole area remains still grey and murky. There's never been any clarification, any accountability, despite the call of Council of Europe and the European Parliament for investigation there. Now, the positive thing in all this is the way in which the courts have stood on the side of human rights and have actually asserted themselves against an extension of executive state power. But on the other side, of course, has been the single-minded way in which the government pursued that. Now, whether this government will do the same remains an open question. It is a coalition government. There are two parties with very different views in the government now on these issues. But we shouldn't forget the big discussion around the Human Rights Act. The Human Rights Act has been seen as an obstacle to upholding security. And there's been a lot of discussion about British values, British Bill of Rights. Well, in reality, in substance, it may not make much difference because many of the principles going back in English law are principles that are now part of human rights principles. But it does make a great difference in terms of the political message that it sends out, because it delinks Britain, it would delink Britain from the multilateral system. And what kind of a message do you send when you do that to the rest of the world? Because we know that one of the big consequences of this approach to security has been the way in which others in other parts of the world have interpreted it. They have seen it as a license. Governments that do torture, that do have arbitrary detention, have seen it as a license to continue doing so now with less consequence. It's also created, I think, a great deal of cynicism about human rights, particularly in the developing world, where human rights are seen now as tools of Western foreign policy. You know, Amnesty International did a survey in the Middle East a couple of years ago to find out about public perceptions on human rights. And what we found was very, very interesting. This was in an age group of 18 to 25-year-olds in 5 different countries in the Middle East. We found that in terms of their position on torture, arbitrary detention, and so on, their positions were no different from what you would find in Western society. But they immediately associated human rights with Western policy. I didn't see it as global values. And that's quite dangerous, because obviously that undermines the notion of the universality of human rights. Now, one of the big fallacies in this whole area is this idea of balancing human rights and security. And I say it's fallacious because it presumes that human rights law and effective counterterrorism and security measures cannot be squared. And I think that is wrong, because the human rights architecture has been very carefully built over the years by governments, not by NGOs, but by governments, and is in fact a very adaptable and durable system. There are rights which may never, should never, and need never be restricted, such as freedom from torture and ill treatment. But there are also many rights on which restrictions can be placed, providing they are done in a certain way and for clear, proportionate reasons. So both lawful counterterrorism measures and protection of human rights are vital functions of the state. They are not to be weighed against each other. Now, let me move now to the second area which I see as a big issue also in the human rights landscape, and that is the erosion of rights by the market. Now, the Universal Declaration of Rights include both economic and social rights, as well as civil and political rights. But if you look at the discourse on development, if you look at what's happening in terms of the social injustices that create and keep people trapped in poverty, if you look at those statistics of 77 million girls who don't go to school, 1 woman dying every 90 seconds in childbirth or for pregnancy-related reasons, the billion people who lack clean water, these are huge, huge problems. But they're seen as problems outside the domain of human rights. They're seen as economic and social issues that the market can take care of. Now, the Human Rights Act does not actually refer to economic and social rights. The European Convention on Human Rights doesn't refer to that. The UK has not ratified the European Social Charter. And some of you may remember that the court case, I think it was in relation to asylum seekers and their access to social security, where the court had to do I would say, legal gymnastics to find a way to ensure the entitlement of asylum seekers to those provisions, to the social security provisions. Now, I think that this is a very dangerous thing, where economic and social rights remain as second-class rights in much of the discourse and the law here in the UK. There is still a great resistance among governments, Western governments, to looking at economic and social rights as rights. Interesting enough, although they wouldn't challenge the idea that children in this country, all children have the right to go to school, but they would not want to translate that as a human right. In the US, we've seen the big debate on the right to health. I was in Germany 2 weeks ago, where the Chancellor's advisor there, argued with me about whether economic and social rights are rights at all. Now that's in Germany, in Western Europe. If I had had that argument in Arizona, I might have understood it. Now, there are many reasons that are put forward, even by legal scholars, as to why they are not rights. The argument is that they don't actually identify clear duty bearers. If children are not going to school, or if people don't have jobs, you can't actually say the government is responsible for that. And so therefore they are not rights. Now, you have arguments on the other side as well, that you don't have to, the state doesn't have to perpetrate a violation in order to have a responsibility to deliver it. There are arguments that economic and social rights cost money, and therefore it's an issue of resource, and therefore should be an issue for the political leaders to decide and not for courts to adjudicate. Well, civil and political rights also cost a lot of money. Courts, fair trial, police systems are not cheap. There are arguments that courts will not be able to enforce economic and social rights. But well, there are 42 countries of the world that have actually legislation on economic and social rights, either in the constitution or through national laws. And there are courts that are regularly now adjudicating in South Africa and in India, for example. So courts have found a way to adjudicate in these rights where there are certain issues on which they will clearly adjudicate, but there are other areas where they will defer to the executive. So they have figured out ways of dealing with this. But it is unfortunate, nevertheless, that when you look at international development policy, look at the Millennium Development Goals, for example, you don't see economic and social rights in there. And yet human rights would add so much to issues of poverty eradication, whether in this country or abroad, because they would bring the notion of universality. So you couldn't argue, for instance, when it comes to women's rights, different standards. They would put a focus on the human being. And I think that's very important if you look at the way in which economic development is taking place. We're talking about growth now coming back. Economy is growing, but it's a jobless growth. It's not bringing employment. Now, if there's a right to decent work, you would look at economic strategies in a different sort of way if you took the human rights perspective. The human rights perspective puts a focus actually on outcomes that benefit human beings. So you wouldn't talk only about building schools, but whether girls are getting equal access to school. You wouldn't only talk about whether agricultural production is going up, but whether malnutrition is going down because there is a right to food. So you would take a very different approach in the way in which you look at poverty. You would also expose the inequalities. Discrimination is a major issue when it comes to poverty, whether in this country or abroad. But if you don't take a human rights perspective, if you don't bring in the idea of equal access on the basis of the principles of economic and social rights, then of course you miss out the whole issue of discrimination. You introduce user fees. You price the poor out of the market from basic necessities, from basic rights. So this whole area of economic and social rights will grow in greater importance. You can already see that in the way in which the debate on development is moving in the global south. Yet it is something on which here in the UK it's still a very grey area, if not a black hole. And so I think that is an area to which greater attention needs to be given in the future. Now, turning to my third point about the extraterritorial reach of the law, now that's the good news part of it. Now, Louise Arbour, the former High Commissioner for Human Rights, had described the development of international human rights law as a maturation process. She said it moved from the declaratory era through a monetary and denunciatory phase into an era of enforcement through personal responsibility. And one of the clearest examples of that enforcement phase is, of course, the creation of the International Criminal Court. And that is a very interesting development because of the notion of universal jurisdiction, because of the way in which, finally, issues of impunity for the worst human rights crimes are being addressed. The court is operational. It opened its first trial with Warlord on the issue of recruitment of child soldiers. Now, another very interesting development, a quieter one that's happening, is, of course, in the area of business and human rights. how to make big business responsible for human rights. I talked about poverty and economic and social rights, but that, if you look at that area, a big business is a very big player. And yet, what responsibility does it have? The traditional concept of human rights is about the relationship of the state and the citizen. It doesn't recognize non-state actors, and yet non-state actors today are getting more and more powerful. I must say, over the last 10 years or so, there has been progress here. 10 years ago, big companies would laugh at you if you walked in and talked to them about human rights. It had nothing to do with them. They were there to make profits. Human rights were the responsibility of governments. But today, they wouldn't say the same thing. There are voluntary codes of conduct that have been set up. For example, the Kimberley process, the blood diamonds issue. Most of you will have seen the film with Nicolas Page about it. You know how that issue has been put on the agenda and how the diamond industry has agreed to certification to stop the use of diamonds that have been linked with conflict. But the problem, of course, with voluntary codes is it's like law. If law was made voluntary, well, how many of us would follow it? The good law-abiding ones, the good people would do it anyway, but not the ones, but not obviously not the most egregious ones. And that's why what's very interesting to watch now is the work of John Ruggie, the UN Special Representative on Business and Human Rights, and the way in which he's developing the notion that governments have the responsibility to protect people, and companies have the duty to respect human rights. So creating a kind of a due diligence responsibility on the state to ensure that business lives up to its human rights responsibility. Now, the final point I want to say is what you see happening here is actually the changing nature of sovereignty, where sovereignty is seeping upwards to the European, to suprastate structures like the European Union or to international institutions, sideways to business, but it's also seeping downwards to civil society and local community groups. And there I see a huge area of hope, because if the one actor that has pressed consistently for human rights, if I can call it as an actor, because there are many, many actors involved here, it is civil society and global civil society, the networking that is taking across the world, the way in which social movements have made human rights their own, whether it's women's movements or movements of landless peasants, workers, and so on. And they are pushing human rights at great risk to themselves. But what it actually shows also is that human rights, and I think it's important as lawyers to remember that, human rights is more than text. It is voice, the voices of people, the experiences of people. And as you study human rights, I hope you will focus on that alongside the legislation. It's the reality, because it's about real experience. Now, looking ahead, there are new realities out there, geopolitical change, the emergence of the G20, China, which will be the second largest economic power, I think, shortly. These are all going to have huge impact on human rights because they will show a fractured vision at the global level between China on the one hand and the US on the other, for instance. Now, that's going to be a big challenge about creating a unified vision. But at the same time, we will also have big challenges of poverty, of climate change, various issues they will throw up, of human rights, of injustice, of inequity, how you deal with them. These are very big challenges. And it's very important that a country like the UK take its responsibilities and contribute to that process. The UK has played a very constructive role at the international level. For instance, promoting a treaty to control arms, promoting the International Criminal Court. Now, that is why it's very important that the Human Rights Act, whatever you call it in the future, a Bill of Rights, doesn't matter, but that it is based on international principles and it is seen explicitly to be part of that same multilateral system to which we would want others to sign up to. Thank you.